I can tell that we have a plea agreement. Because I have a written copy of that. Ms. Carey, for the record, please state the agreement.
Thank you. It's my understanding the defendant will plead guilty to count 2. Will dismiss count 1. And there's a kilobrew for treatment under 7411.
Exactly. Thank you. Mr. Powell, is that how you wish to resolve today's case?
Yep.
Please raise your right hand. Sir, do you swear or affirm that the information and testimony you're about to provide shall be the truth, whole truth, nothing but the truth?
Yes, sir.
You may lower your hand. All right, Mr. Powell, looking back here on I know this is a new file because it's a 2026 file. Do I have a felony information? Oh, there, hold on. I have a felony complaint.
Speakers just found out.
Yeah,
I have the information.
yeah.
It was signed on the 13th.
So this is already, was it set for a plea?
It was set for a plea.
All right, so that's why it's not a final pretrial conference. Nobody corrected me on that, but that's okay. So there was a plea agreement reached real quick. Why don't you go ahead and hand me your copy, Ms. Carey, of the felony information. This one is so hot off the presses, I don't even have all the paperwork. All right. Mr. Powell, you are currently charged on this. Oh, wait, nope, I was back to ask you this question. On December 27th of this past year, back in 2025, so barely a month ago, were you on probation, parole, or bond?
Yes, sir.
Thank you. You are currently charged on this felony information with 2 counts. Count 1 is the possession of the controlled substance methamphetamine. That's a felony punishable by up to 10 years and or up to $15,000. That count will be dismissed. Count 2 is possession of a different controlled substance, cocaine, in an amount less than 25 grams. That is a felony punishable by up to 4 years and or up to $25,000. That one, I'm told you're going to plead guilty to. Is that what you believe you're doing today?
Yes, sir.
Now, I have a pretrial agreement here that needs to be signed, and it talks about another term of the agreement. Besides dismissing count 1 by the prosecutor and you pleading guilty to count 2, there's an agreement that there would be some kind of benefit at sentencing. That benefit is a killover agreement, which means that if we come back to court and I don't go along with it, then you would have the right to withdraw your plea and come back to the stage of this proceeding. That killover agreement is that you will be placed upon treatment under section 7411 under the Public Health Code. The Public Health Code, which is title 333, starts off in a section in chapter 7 with drug-related offenses. Well, 7411 is within that chapter, and it says that as long as you don't have any prior drug convictions and you enter a plea of guilty, I'll put you on a period of probation. That could be up to 36 months. And if you complete that period of probation successfully, which means you don't violate any of the terms or conditions, you would have the right to have the charge dismissed at the end of that probationary period. You understand? I need a verbal answer.
Oh, you guys said the word yes.
Yes.
All right, thank you. I got you. You were shaking your head. Yeah, I got it. But
Yeah, I was thinking.
well, good. I didn't see any smoke coming out. So, but anyway.
Yeah, I'm surprised.
All right. But here's something that's really important. When you're on 7411, I can guarantee you the terms are going to be you can't use or possess controlled substances, which, by the way, includes, by legal definition, recreational marijuana. If somebody pops up, the number one reason they lose 7411 and the conviction becomes permanent is if they test positive. So just need you to be aware of that. So you're thinking about these processes. By gosh, if I'm going to do this and I enter this plea I'm committing myself to doing whatever Judge Elmore says for whatever period of time he gives me. Generally, it's about 18 months, 24 months for the periods when I give. I rarely give the 3 years unless the person's got, well, unless it's really appropriate. All right, do you understand all that, sir?
Yes, sir.
All right, good enough. Now, by entering a plea of guilty, and if I accept that plea, you're not gonna have a trial of any kind. Does that make sense?
Yes, sir.
Now, Mr. Powell, I'm holding up a form that your attorney gave to me, and at the top it says advice of appellate rights, and then the bottom appears to have your signature. Is that your signature?
If I can see it, yes, sir.
Oh, hold on. Samantha, why don't you come on up here? She's been sitting over there too long. That's okay. No. I don't mind. See, I gotta get Samantha up and do something.
I made sure you read them with his voice.
All right, no problem. Is that your signature, sir?
Yes, sir.
All right. One of these days, I'll remember to put an extra pair of reading glasses out there at that table.
That help.
Sir, did you read through these or go over them with your attorney before
Yes,
you
sir.
signed?
Yes, sir.
Did you understand those?
Yes, sir.
And even more importantly, do you understand that if you plead guilty and I accept that plea, you will be forever waiving these rights as they apply to this particular case?
Yes, sir.
Now, you'll also be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me right now on the record. Have there been any other promises, threats, inducements, guns put to your head, torture to make you plead guilty? All right, good. Ooh, I was getting worried there. Therefore, you enter the plea of your own choice.
What's that?
Are you entering the plea of your own free choice?
Yes, sir.
Has anyone made any promises to you that what an exact sentence would be?
No, sir.
I know Mr. Hartel has probably talked to you about sentencing guidelines, applied his depth of experience of sitting in front of Judge Elmore week after week after week, and try to give you an idea of what the sentence could be. First of all, I want to know that's an estimate. Do you understand?
Yes, sir.
It's not a promise. Okay?
Yes, sir.
All right, good. Do you have any questions before I take your plea?
Any questions? No, sir.
All right, good. As to count 2, possession of the controlled substance, cocaine. How do you plead?
Guilty.
Before I can accept that plea, I need you to tell me what it is that you did that makes you guilty of that offense. Turn your attention to December 27th in 2025 in Springville Township here in Wexford County. What did you do, sir? How'd you get caught? What happened?
I got pulled over for making a wide right-hand turn. The officer pulled me out of my vehicle, searched me, found coke on me.
And where was the cocaine found on you?
In my coat.
Did you? I know this sounds like a very obvious question. What, did you know it was in your coat? Or did you, was it your coat? Let's do it that way. Start this way. Was it your jacket, your coat? Here's what I don't want. Here's what I don't
It
want.
wasn't my coat.
All right, wasn't your coat. Got it. Doesn't need to be. Sometimes people try to come in later on and say, well, it wasn't even my coat. I picked the coat up off the ground, put it on, wore it around for months, but I never checked in the pockets.
Your Honor,
Yeah.
I'm self-employed. All
So-
my employees have the same coat.
Okay, so here's, all right, so that's okay. That causes me to ask you the question in a different way. I do this a lot, so bear with me. Did you know that the cocaine was in the coat?
No,
How do you, was it yours?
no.
Okay. All right. So the answer is I cannot accept a plea. Why? Because when a person pleads guilty and says they're guilty, there's a reason why I have to ask them, what did they do? Because some people like to say, oh my gosh, that person just, or I just accepted that plea. I was forced to, I didn't really want to, yada, yada, yada. I don't buy that because, at least with me, I always ask the question, did you do it? Did you know it was there? And if you didn't, then I can't by law accept the plea. And not only is it illegal, it's unethical, and it just does not happen in this courtroom. I don't care if it happens somewhere else in the world, but it doesn't happen where I'm here, when I'm here. All right, so I'm gonna take a brief recess here in place. Mr. Hartel, you can speak with your counsel, your client. Before I do the recess, sir, don't think that anything here is about forcing you to do a plea. I don't care. I have no I've got no dog in the fight. We're in recess.
Figure. Now, this is a pretrial, so it's not a total loss.
No, we're not gonna cut. So here's what I'm doing with pre-trials. We're not on the record yet. I'm starting to do something else different with pre-trials. I'm gonna give you all a form that you're gonna complete when you're here. The two attorneys and the client will sign it. That way I know the client is here. I know the defense attorney has met with the client. And I know the prosecutor has communicated. And then you're just gonna leave it. So I'm gonna keep this case set for a pre-trial. This form also can be used by we're not gonna do it all the time though. If you who can't make it, counsel for a pre-trial, but it's gonna make them still meet with the client. All right, here we go, back on the record. All right, so we're back here on the record now for People versus Powell. Counsel, defendant still here. Mr. Hartel, are we gonna enter a plea today?
Not today, no, Your Honor.
Because of my statements earlier, I already elected and said that I do not accept the plea as presented. Therefore, there is no plea on the record. We're going to have this case set for an initial pretrial conference. Sir, Mr. Powell, when a case is bound over from district court to circuit court, my staff does a couple things. Number one, we could do an arraignment again, but I have a what's called an LAO that says we don't do those anymore. So it's just on paper. The next thing is I give you a scheduling order. That should be sent out by my staff within the next week. We also had you come here for a pretrial conference. Today you see me do a lot of final pretrial conferences, which is the conference held just before the trial date. An initial pretrial conference, you guys can come. If you all reach an agreement, great. I'll take it, put it on the record. If you don't, I have a form now that you all the attorneys are going to sign and prepare that says, Judge, I've done all my, I've told the defendant what he's charged with and just certain things. But anyways, we'll have you back here probably in the next couple of weeks. Your bond hereby continues, no modification. Oh, wait, sorry. Are you asking for any modification? He's not in jail, so.
No modification request.
Copy that. I assume you're probably doing some kind of testing. Is that right?
Yes, sir.
All right, good. That testing is really important. Bond is not allowed to be used as a punishment. Why? I love it when people don't understand the law or the Constitution. Because you're innocent until proven guilty. So I can't use bond to punish, but I use bond to protect society and the defendants. What you don't want to do, I have no reason to say or believe that you would, because you don't want to test positive.
I haven't yet.
All right, well, hold on. Don't say yet.
Let's
stay positive.
Ain't gonna happen, sir.
All right, thank you very much. All right, Mr. Powell.